SJC-12083, Genentech, Inc., v. Commissioner of Revenue.
Good morning, Your Honors. Kate Batten. I'm here with my colleague Richard Call on behalf of Genentech, Inc. The central question in this case is what portion of Genentech's net income is properly subject to Massachusetts tax. Genentech is a biotechnology company that's headquartered in California that develops drugs produced from living cells. During the years at issue, 1998 through 2004, Genentech had a minimal presence in Massachusetts. The first issue is whether Genentech qualifies as a manufacturing corporation, such that it would be required to apportion its income to Massachusetts based on a single sales factor apportionment formula that only looks at the amount of sales it made to Massachusetts in relation to its total sales in the US. Genentech maintains that it's not substantially engaged in manufacturing, and therefore it should be allowed to use the standard three-factor apportionment formula that takes into account its property and payroll in the state, along with its sales. Because Genentech had very little property and payroll in the state during the period at issue, the single sales factor apportionment formula results in a significant tax increase. The second issue relates to whether the Massachusetts tax scheme is unconstitutional as applied to Genentech. The ATB's ruling has the effect of raising Genentech's tax liability by approximately 200%, while simultaneously denying Genentech the tax credits other Massachusetts-based manufacturers enjoy. It's clear from the Department of Revenue report that Massachusetts adopted a single sales factor regime to decrease taxes on in-state manufacturers.
But is your view, on the constitutional question, is this, I know you have both, which do you think is your primary? Is it the equal protection or the dormant commerce clause?
I think it's the Commerce Clause, Your Honor. I think there's also an equal protection argument, but I think the Commerce Clause argument is...
You get all those credits in California, don't you?
There are different credits. The scheme in California was different during these years at issue. The issue here is the single sales factor coupled with the credits that I would argue makes the scheme unconstitutional.
Could you address the waiver issue on the constitutional claims?
Yes, Your Honor. The waiver issue, Genentech argued this issue in its protest to the ATB, so I don't believe it's waived under the cases that say that if anything, if there's more than hinted at below, it's proper. I also think the record has been fully established to address this issue. And I think in the interest of judicial economy, I would urge the court to address it because this same issue is pending in the ATB currently for the subsequent audit cycle.
So is it your contention that if Massachusetts were to say, if you come here with your manufacturing, we will give you a tax credit for coming here, which many states do, that that's a violation of the Dormant Commerce Clause?
Not per se as your hypothetical is. I think the issue here is that there's no connection between the incentivized activity and the tax burden. I think if we had these same credits with the three-factor apportionment formula, it would cure the inconstitutional infirmity. The problem here is that the tax is measured based on sales only, yet in-state manufacturers are receiving investment tax credits and research and development credits for in-state activity. That's not that.
But in California, is that where you're manufacturing? Is that where this work is done?
The work is done in California.
Okay.
The California credits are different than the credits
No, I
in
understand
here.
that. But if you're analyzing the Dormant Commerce Clause, you have to presume that every state has the same statute that we do, correct?
That's right.
So if California had the same statute that we do, you would get your credits in California, and a Massachusetts-based manufacturing corporation would not, correct?
That's correct. I think that looks at internal consistency. If we're talking about the Commerce Clause, I think what you've just articulated is an internal consistency
true.
test. And what I would argue here is that the tax scheme is externally inconsistent. And that test measures the actual, whether the tax actually reflects a reasonable sense of how the income is generated. Under the tax scheme, a taxpayer can decrease its tax liability by increasing its activity in Massachusetts, which results in an inverse relationship between activity in the state and the tax imposed, which results in external inconsistency. And I think that's supported by the Supreme.
That again, please.
So there's an inverse relationship here between the tax and the credits and the activity in the state. So if a in-state manufacturer has more operations in the state, makes more investments in the state, which is what the legislature clearly intended to encourage more in-state activity, they can decrease its tax liability, so there's an
But
inverse
if they-
relationship.
If they happen to also do all their sales in Massachusetts, I mean, isn't that somewhat of an apples and oranges, or not?
No, I don't believe so. I think it's really that what is being incentivized here is activity in the state, but those incentives are not tied to the tax burden associated with those activities. I think this entire constitutional infirmity could be cured with a three-factor formula.
Why does that cure it?
Because then the in-state activity, the manufacturing activities, would increase the property and payroll factors. You would have employees working at the manufacturing plant. You would have property associated with that. That burden would increase, and it would be offset by the credits. In the case of a single sales factor, you're just giving more benefits to in-state manufacturers at the expense of out-of-state manufacturers. It's a coercive scheme here, and I think a case that looks at this issue is.
So does that mean that no state can ever give any kind of incentive to have a business locate in the state?
No, not at all, Your Honor. What it means is that the incentive must be tied to the increased tax burden that the incentivized activity creates. The courts have commonly.
Sorry, I don't get that.
Okay,
It
so.
must be tied to the, I mean, let's sort of imagine, let's imagine Kentucky wants to bring Toyota there. They say, we'll give you many tax credits if you build a Toyota plant in Kentucky.
Well, I think, first of all, we could talk about property tax credits. Those would be perfectly
Let's
appropriate.
assume it's excise tax credits.
If we're talking about income tax credits, I think that it would have to be credits associated, if it's property and payroll, they could only be constitutional in the context of a three-factor formula. There's no increased tax burden by that those companies face by putting any of those activities in the state if it's a single sales factor. So if they put another plant in, they put more people in the state under a single sales factor, that burden isn't increased. So you're just benefiting them at the expense of the out-of-state companies. I mean, it was clear in this context that that's what the Department of Revenue intended. Of course, we've been focusing on the constitutional infirmities, but I would argue that in the first instance, we don't even have to get to the constitutionality because Genentech isn't engaged in manufacturing. The test under the statute for a manufacturing corporation is defined as a corporation that's engaged in manufacturing, which in turn is defined as transforming raw or finished physical materials by hand or machinery, and through human skill and knowledge into a new product possessing a new name, nature, and adapted to a new use. Genentech here isn't even engaged in manufacturing such that it would be required to use this single sales factor.
The protein extraction isn't a new product?
No, Your Honor. What happens is the scientist does, in fact, insert DNA into the.
We start with E. coli and hamster ovary cells? Is that what
Yes, yes, Your Honor.
end up with a
Chinese
protein?
hamster.
Well, but that is,
Chinese hamster.
that's right, Chinese hamster ovaries.
And then we end up with a specialized protein.
You do, Your Honor, but what happens is the cells themselves produce that. It's not hand or machinery, and that's critical to the test. So,
In huge vats and extraction processes and, right?
well, they're huge, they're sure that
I mean, this is much different than crushing rock and making gravel and breeding animals and making baby animals.
I don't think it is, Your Honor. I think, I mean, they do, the ATB was caught up on the fact that the scientist does insert the hamster ovaries or the DNA into the cell, but then it's a natural processes where the protein of interest is created, and those big bioreactors and the pictures you see in the commissioner's brief, that's just all part of the temperature-controlled environment so that this natural processes occurs.
Yeah, but you've manipulated the process before the natural process starts.
You've done something, but you haven't. The key to the test is you haven't transformed something.
Yes, you have.
By hand or machinery.
You've
It's the
transformed it
cells
by
themselves
changing the
that transform.
DNA.
But don't you transform a big rock into a small rock, like the Quarian case, right? I mean, aren't we talking about something that's materially different?
I don't think it is. I think what is produced from the cell is the protein of interest, and they certainly extract that out. But I think the key is really the lack of transformation. And I think if you find that Genentech is engaged in, if this is engaged in manufacturing, which I would disagree, they're not engaged in manufacturing in substantial part, and that's where we get the test.
Help me on that. As best as I understand your argument, you're saying that Genentech, rather than put money into a mattress, basically takes all its money that's sitting around, puts it into a bank until it needs it, and then withdraws it as needed. And then as more money comes in, it puts it in the bank, and that every time it withdraws money from the bank, that you consider to be a receipt.
Well, it's certainly treasury receipts and return on short-term investments and commercial.
Whatever you call, whether it be a bank account or a treasury bill, but essentially, as opposed to having money in the mattress, you're basically keeping it in the bank in order to get some return on that. But you're measuring your receipts not by the investment return or the interest, you're measuring it by the total amount of withdrawals. Am I correct in that?
That's correct, but the test is on the gross receipts. And I would submit that the plain language of the statute is gross receipts, and that there are other tests that would determine whether a company is engaged in manufacturing that Genentech failed. It doesn't have 25% of its property, associated with these so-called manufacturing activities. It doesn't have 25% of its payroll associated with manufacturing. It failed those tests. We're just looking at gross receipts. It's a bright line test.
It's your view that a company, in order to avoid can simply put money in the bank, take it out, put it in, take it out, and every time it takes it out, it's a receipt, and you can say, aha, all those are receipts, and our gross manufacturing income is dwarfed by the receipts we're getting from the withdrawal of those funds. That's the argument.
The argument is that gross means gross, and that the plain language of the statute is gross receipts. There are other tests. We don't have to worry about what you're...
So I mean, this is just making clear Chief Justice Gantz's question. You deposit your money in a bank with you don't get interest. That's probably not legal, but you don't get interest. It's an interest-free account. So you put in the principal, you take out the principal, and you get a piece of paper that says I'm taking out $100,000. That's a gross receipt?
There are receipts associated from the Treasury activities, yes. And the other courts have considered this. In California, in the General Motors case, in the Microsoft case, they said gross means gross. I mean, it's a bright line test. The legislature clearly knew how to make a carve out for receipts to get rid of these types of receipts. It did so just a few paragraphs above in the same statute. So had they wanted to make a carve out for purposes of this test, they surely would have done so. So I think it's just the canons of statutory construction here support the argument that Genentech's not engaged in manufacturing a substantial
What
part.
would be the purpose of that, though? Why would the legislature do what you're suggesting?
Why would they not take those receipts out?
Well, why would they think it's a good idea to have gross receipts mean what you say it means?
Well, because I think they're trying to get at the question of whether a company is engaged in substantial part in manufacturing in the state. And if the company doesn't have the property associated with it, doesn't meet that test, doesn't meet the payroll test, then you're going to look at receipts as just a third way of determining it.
So in your interpretation, if I'm a business which has $1 million in sales and my total receipts, well, $1 million in sales, I put that million, I basically put that $1 million into a savings account and then withdraw it every hour. I've got, over the course of 8 hours, now $8 million in receipts because I've put all the money in, taken it out, put it in, taken it out. So now it's gross receipts of $8 million because every hour I put it in and take it out. Is
Yeah,
that-
that's not what happened, but I
No,
would.
I know, but that
think-
would be, that's how you would say we should interpret the statute, that every withdrawal of money from your own bank account is viewed as a receipt.
I think gross means gross, and so, you know, the court, or the legislature clearly knew how to make the carve-outs that you're concerned about, and I think we have other tests that would protect a situation where someone is truly substantially engaged in manufacturing by virtue of the property and payroll.
Okay, thank you.
Thank you.
Mr. Goldberg, good morning.
Good morning, I am Brett Goldberg. For the Commissioner of Revenue, with me is Jamie Zhao, and may it please the court. I think as far as the gross receipts question, the court has exactly focused on the flaw in Genentech's
But why isn't
interpretation.
your sister correct? Gross means gross.
I think gross in the statute is actually ambiguous. It's ambiguous because it's used one way where gross includes the return of capital. But if it means return of short-term capital for purposes of this gross receipts test, then you end up with a result that's clearly contrary to the intent of the legislature.
What do we make of the carve-out, though, that your sister brings up that's apparent in another part of the statute, where there is a carve-out for this type of investment income?
I think it's a bad drafting. And I concede that there's, the word gross receipts means something slightly different in the two contexts. They were enacted years apart and could have drafted it better, but to interpret the statute the way Genentech wants leads to an absurd result, contrary to the intent of the legislature, which clearly was to let these ratios, the gross receipts ratio among them, serve as a proxy for the amount of business energy that was devoted to the manufacturing process. If the Genentech's position is correct, it blows that out of the water. It makes the fraction totally useless.
Well, okay. Could you address the external consistency argument?
I think the argument here is that single sales factor and the ITC considered separately are constitutional, but together somehow they're unconstitutional. And I think that's incorrect because although both of them are benefits to manufacturing corporations, they're additive. There's no synergy that makes them together unconstitutional.
But the argument is, and I just don't know enough about this, but the argument is if a state gives an incentive, like the ITC, the tax benefit, if I understand correctly, there needs to be a relationship between the incentive and the tax. Maybe I've got that.
The incentive is to reduce the tax. So yes, of course, it's the legislature's intent
Right,
to...
but it doesn't have anything to do with, it would have something to do if you taxed all three of property sales and, but it doesn't have anything to do with just plain, what's the one I'm missing? Sales.
I don't think that, perhaps I'm misunderstanding, but I don't think there's any relationship between the single sales factor versus the three-factor formula and the investment credits. They're totally separate. They involve different tests. If you're a manufacturer under one, you're not necessarily a manufacturer under the other, although often you are. The legislature intended by both of these statutes to encourage growth of the economy in the Commonwealth, to grow jobs here. That's very clear. And both of these statutes are intended to do that. Yes, you are going to, if you invest in new machinery and manufacturing facilities in Massachusetts, you are going to get the investment tax credit.
But you may say, so you get the investment tax credit, I think the argument is, but that has nothing to do with whether your sales are here or elsewhere, right?
That's correct. The apportionment formula doesn't look to where your manufacturing is, where your headquarters are, anything other than where your sales are.
Right.
Under the three-factor formula, it is correct that an increase in property in Massachusetts would result in an increased apportionment factor. Right. And that same investment in Massachusetts could potentially also give you a credit. But there's no problem with that. There's no contradiction.
Could you address the waiver issue?
Yeah, I think it's clear that the taxpayer has waived its arguments with respect to the single sales factor because although it was raised in their petition to the Appellate Tax Board, it was, I think it's fair to say, explicitly waived and not argued, not presented before the Appellate Tax Board, not subject to the tax board's opinion. They're raising it really for the first time, absent the petition. They raised it in the petitions, abandoned it completely, and then raised it again. The Appellate Tax Board didn't have a chance to address it.
The single sales factor? Or you mean
The sales factor, yeah.
the constitutional arguments with it? Is that
Well, any argument with respect to the sales factor. There was no argument at all with respect to
the whole case was about whether it was a manufacturing corporation or not? Is that what you're saying?
Three things. Whether it was a manufacturing corporation, which would make it subject to single sales if the manufacturing was substantial.
Right.
And secondly, the constitutional issues. But the constitutional issue was only raised with respect to the investment tax credit, not with respect to the sales factor. And I think it therefore has been waived. But I think...
But are you saying that other aspects of the constitutional argument have not been waived?
The constitutional arguments with respect to the investment tax credit, I don't think have been waived. The equal protection argument, again, was not raised in the petitions or at the Appellate Tax Board, and I think has been waived. But I think that the taxpayer's primary claim is with respect to the Commerce Clause, not with respect to the Equal Protection Clause.
And how do you square this case with the case involving the breeding of, was it pigs? Or was
Mice.
Mice. If somebody is harvesting eggs from chickens, is that manufacturing, even if it's done in a major way?
No, I don't think so. But if the eggs are then used to make some other product, scrambled eggs in a carton, that certainly would be manufacturing. And the focus, I think, here that makes this case clearly involve manufacturing is when you started looking at the huge vat of cells and proteins of various kinds and glycose and detritus that's not useful for anything, and then through a series of complicated purification processes end up with a vial of a purified protein that's suitable for human consumption. That's a big change. And as Your Honor pointed out, nothing like making big rocks into small rocks. If I can go, I want one point with respect to the constitutional claims. There's two arguments. One is that the legislature was purposefully discriminatory by enacting the single sales factor, and two, that the single sales factor results in a gross distortion of the taxpayers' business activities in the state. As to the latter, the apportionment changed from about 1.5% to about 2.5%. To say that that increase results in a gross distortion assumes that the 1%, 1.5%, was an objectively correct number. That, in turn, assumes that the three-factor formula is the correct formula. And that's exactly the proposition that the Supreme Court rejected in the Mormon case. It said that the court's not going to get into second-guessing the states with respect to apportionment formulas. Any one of them is inevitably an estimate, and one is as good as another, so long as Your Honor pointed out, they don't result in an internal inconsistency. As to the intent of the legislature to discriminate, I think you can fairly assume that the legislature was aware that the new single sales factor would result in general, a corporation with most of its facilities and personnel inside Massachusetts having its tax decreased, and if it had its facilities and personnel mostly outside of Massachusetts, but with Massachusetts sales, it would have it increased. But I don't think that awareness constitutes discrimination. Awareness of disparate impact in the equal protection context clearly does not prove invidious discrimination, and I don't think it does here.
I'm sorry, I lost you a little bit there. I gather there was discussion in the legislature that said this would have this effect. This would encourage people to bring their manufacturing here because it would reduce their tax.
That's right. The intent of the legislature was to, in effect, eliminate an impediment to investment in Massachusetts. Because with the three-factor formula, as we discussed, if additional investments are made in Massachusetts, the tax goes up, all else being equal, and that's therefore an impediment, a disincentive to investing in Massachusetts. And that's precisely what the legislature sought to correct.
Are we to take meaning from the distinction between we're going to eliminate an impediment to investment versus we're going to encourage investment? Is there?
No, I think they're the same thing. But what the sales, I'm only making the point that it encouraged investment by removing the impediment.
And you're saying that they can do that?
Absolutely. Provided it doesn't violate the internal consistency clause, internal consistency rule. States are given wide latitude. It's very clear to adopt any apportionment system they want. And this particular system, the single sales factor formula, was specifically approved in the Mormon case, and the statute here is indistinguishable from the statute in Mormon. And indeed, some 25 other states, in addition to Massachusetts, have adopted the single sales formula.
With a investment tax credit as well?
22 of those also include investment tax credits or research credits. Yes. They, like Massachusetts.
We have both? I mean, I understand the investment tax credit is what we're talking about, but isn't there another credit that also happened at the same time?
Yeah, the R&D credit, the
R&D
research credit.
right.
I would point out, though, that both of these credits are available to Genentech if it invests in Massachusetts.
Right.
And in fact, it did claim research credits and was given the benefit of research credits. It could certainly, if it established a manufacturing facility here, would earn investment tax credits too. As to the, if I can move to the subsidy question, the ITC question and its equivalence with a subsidy. The Supreme Court has specifically held that a subsidy is permissible because a state, in the words of Professor Tribe, the court reasoned that the clause simply does not apply as a source of negative implication to state decisions to distribute government largesse on a basis that favors the state's own residents. And that was a comment on the Alexandria scrap case. And Justice Stevens, in his concurrence in that case, made clear that a credit was equivalent to a subsidy, and the state can give its largesse in either form. Because they're economic equivalents, they're also equivalent under the Commerce Clause, because the Commerce Clause looks to practicalities, not to formal language.
Okay, thank you.
Thank you.